Good morning, everybody, and thank you, Siobhan, for opening this event and for your comments. And it is with great pleasure that I welcome each of you to UCC this morning. And before I begin my own presentation, I'd like to sincerely thank each of you, most of whom I've met in the registration process, but for taking the time out of your daily roles to come here to Cork today to just take part in this event, this workshop. And I sincerely hope that each of you take the opportunity to connect with other people working in different organisations that you may have cause to work with in the future, to avail of the downtime between presentations and also the lunchtime session. Because I suppose the motivation for this morning was realising that my funding is almost over and thinking about how best to put the early research findings to use. And I think it's very important to bring people together to discuss some of these findings and see how we might move forward from them. So I'm very encouraged to see such a diversity of organisations represented here today, and I hope we can capitalise on that. Amongst those of you in attendance here are representatives from deaf organisations that have consistently supported my efforts in this research over the last 10 years, and it is absolutely fantastic to have you in attendance here this morning to engage with other stakeholders. Similarly, I'd just like to allude to the fact that Claire Edwards is here, and it was Claire who supervised my PhD work and actually gave me a job working as a project researcher about victims of crime, and that's how my career research path took the turn it took. And so I'm very grateful to Claire for that. I'm very excited now to share the findings from this particular piece of research. I'd just like to say it's a very casual format this morning. If there's anything at any stage that you wish to raise a question during a presentation, please don't hesitate to do so, and there will be time afterwards for questions and answers also. Okay? So, in terms of what the presentation is going to look like, I'll start broadly and I'll focus in more then on issues specifically relating to deaf victims of crime. So I'll talk a little bit about the origins of this research and the context in which I've been working. I'll look then at something quite theoretical, I suppose, the idea of Ireland being a common law jurisdiction and how the criminal justice process in operation in this country is one that centres on adversarialism, and in particular the system of orality. Now, we've put a few of these key terms up behind us here on the board, so it may be of interest just to see them there, and maybe we can discuss them at greater length later on in the day should the opportunity arise. I will really like to focus my presentation on the insights that have come from deaf victims of crime themselves, because I really believe that's where the richness of this research lies, and I look forward to sharing those with you. But for today's presentation, I've decided to focus specifically on the theme of communication at the reporting of crime stage, because that was without doubt the strongest thread that came through in the data that I collected, so I'd like to discuss that. And then to finish, we look at some future directions in terms of international models and other what's happening in other jurisdictions, but also some of the things that are happening here in Ireland that are examples of good practice. And relatedly, I'd like to just express as well a real welcome, but also gratitude to the others that will be presenting on today's agenda, because I think the quick and positive responses received by each of the presenting teams was very encouraging, and I think it points to their enthusiasm around this research topic area as well. So it's a really, as Siobhan said, it's quite timely, but there's also quite a momentum around this particular research topic at the moment. So hopefully there is an opportunity to effect change. So about this research, in 2012, working with Claire Edwards and also Shane Kilcummins, who was mentioned by Siobhan, who is now in UL, Claire was awarded funding from the National Disability Authority to conduct a study called Access to Justice for Victims of Crime with Disabilities. And while we were working on that research project, I was finishing my PhD and writing a lot about orality and kind of the power of speech. And it really struck me that there wasn't much discussion of deafness in general discussions of victims with disabilities. And so I thought about putting together this research proposal, and thankfully it was funded by the Irish Research Council for a 2-year fellowship, and it's due to conclude this coming September. So I suppose to take a giant step back and think about recognising what victims are, who are victims, and how can we recognise them in the criminal justice process. And over the last, I suppose, 30 to 40 years, we have seen a shift where research, which used to be focused on accused parties or people guilty of committing crimes, has now shifted, and we have started to look at the key role being played by victims. And for example, the EU's Fundamental Rights Agency, there's just a quotation from them behind me, what they say in their 2010 document, they define what the right of access to justice actually means. And they say it encompasses the right to a fair trial and the right to an effective remedy or solution. Access to justice includes not only the rights of the accused in the criminal process, but also the rights of victims and complainants. So it's interesting to see that there is this institutional recognition now of victims of crime in such documents. In terms of defining what a victim is or who a victim is, because it was brought to my attention in this research that it's a term that we assume we understand what it means, but sometimes actually it can mean more than we imagine it to mean. So in Justicia's 2014 document, they provide a very succinct definition. And they say a victim is a person who has suffered physical harm, mental harm, emotional harm or economic loss as a result of criminal offence. But also, it may be a family member of a person that has died because of a criminal offence. So there's a slightly expanded definition there, which I think is interesting to keep in mind. So in terms of what's been happening in Ireland around victims' rights, we had an updated version of the Victims' Charter produced by the Department of Justice and Law Reform in 2010, and I'll speak a little more on that in relation to the previous NDA research shortly. But what I'd really like to focus on is what Siobhan has already alluded to, and the upcoming EU Victims Directive about to be brought into Irish law in November of this year. It will replace a preceding document, which was the 2001 EU Council Framework Decision on Victims' Rights. Now, the Victims' Bill is currently being drafted, but what's very interesting is to think about what this directive means for Ireland. And one of the key things that it means is that Ireland will have to report back to the European Commission and to talk to the European Commission about how not specifically deaf rather, but how generally victims' rights have been met. And it will be expected from 2017 will be the first report back to the Commission, and every 3 years thereafter. So Ireland will have a real obligation and responsibility to report back to the Commission and make very clear statements about how victims' rights are being met. So I think this is a real opportunity to be proactive in terms of recognising where the gaps are in service provision and addressing those in advance of having to report back. So to make sure that we're tightening things up and improving the service provision for victims of crime. And not only is it timely in that sense, but it's also essentially an issue about human rights. It's a fundamental rights issue. Somebody becomes a victim of crime, very often it's unexpected and very traumatic. And so they're forced to engage with the criminal justice system unexpectedly, and it wasn't through their own doing. And so the response that the criminal justice system makes to victims is really important, because if the response is insufficient or in any way flawed, it can actually really add to the trauma a victim experiences. So it's very, very important that we hold that in the front of our thoughts. Now, last November, the Minister for Justice, Frances Fitzgerald, made a speech at a conference held by the Victims' Rights Alliance in Dublin. And I thought it was interesting just to pull this particular quote from that speech. She was commenting on the Victims' Directive, and I think it gives us a good sense of what it's about and what it hopes to achieve. I think it captures the essence of the directive. So on the slide behind we have the quote, and it says that the Victims' Directive is the incentive or focusing of organisational attention, which can act as a catalyst for improvement in information giving. As a result, we can expect to see significant improvement across the board. This will go some way to achieving her objective of placing the victim more centrally in the criminal justice process, and not just as a passive observer who is kept informed if someone remembers. So the purpose, I think, and the core role of the directive is to make sure that the victim is held centrally in all proceedings around things that affect them so directly. Now, as Siobhan had alluded to, when we think about victims, it's not very useful to think about them as a homogenous category. Every victim is the same, because that's certainly not the case. I think before somebody is a victim, they're an individual, and they have a set of individual needs, requirements and rights. And we're starting to see a recognition of this diversity. So, for example, in Justicia's 2014 document, which is available online, Know Your Rights on the Victims' Directive, they make a really interesting statement. They say that not every victim deals with the trauma of a crime in the same way. Some victims need more help than others, and they may need access to specialist support services to get them through the trauma of the crime. The directive provides for the individual assessment of all victims of crime in order to identify those victims which need extra protection and who have specific protection needs. So we can see within this document there's an acknowledgement that not every victim is the same. To think then about how people have looked at specific diverse categories, one of the categories that has been strategically recognised are disabled victims of crime to a certain extent. Now, in 1996, the report of the Commission on the Status of People with Disabilities was published. It was called A Strategy for Equality. And a chapter in that report was dedicated to the criminal justice system. And what was said in that was that access to the system is a matter of fundamental importance in a democratic society. And it's recognised as such in the Irish Constitution, the European Convention on Human Rights, and in international law. However, there are many barriers standing in the way of full access to the law and the legal system for people with disabilities in Ireland. These include the familiar ones of access to buildings and to information, as well as specific procedures and practices of the legal system. Now, this report is almost 20 years old, and if one is to take a close look at the many recommendations made therein, it's quite distressing to see that very few of them have actually achieved any kind of traction in terms of action being taken. But there is a recognition therein of disabled persons as a category within the criminal justice process. This leads us on to the research completed thanks to the funding won by Claire Edwards in 2012 from the National Disability Authority, in which issues pertinent to disabled victims of crime were explored. And key things emerging from that report were, first of all, that there is a lack of strategic identification of people with disabilities as a specific group within the broader victim group. Second of all, there was a finding that there was a real lack of data collection on people with disabilities as victims of crime. So the maintenance of records or statistics are really non-existent as such in a very sort of a robust way. One exception that's notable is the Rape Crisis Network and the efforts they are taking to maintain a very rigorous standard of data collection. Ultimately, the report concluded that it is not a level playing field for victims. Certain victims of crime are on a less sure footing in the process than others. And another key thing alluded to was the fact that the Victims' Charter of 2010 is not legally binding. So even though An Garda Síochána make a commitment therein to cater for persons with special needs, as it's termed, again, the Charter is not legally binding, so it is insufficient in terms of actually ensuring people's rights are met. If we look then towards more recent developments, and the Victims' Rights Alliance document of 2014 have demonstrated the way in which the directive we're speaking about is recognising different categories of victims. And I've just highlighted on the screen there that victims with physical and intellectual disabilities or mental health difficulties are among the categories that are recognised as strategically significant. However, I will go on to talk a little bit about how that provision and that recognition is insufficient in terms of recognising deaf access issues. But to return to the directive, it'll place an obligation on all member states, including Ireland, to ensure that victims with disabilities are able to benefit fully from the rights set out in the directive on an equal basis with others, including by facilitating accessibility to premises where criminal proceedings are conducted and access to information. And I'd really just like to zone in on that last point about access to information, because it's a common thread that we can see coming through literature around the directive. I've already mentioned the Victim Charter of 2010. In this document, all of the organisations that I suppose comprise the criminal justice system made statements or a set of commitments on how they would cater for the needs of victims of crime. So you would have at the court service, probation service, all of the organisations that you could expect to engage with, from reporting a crime through to going to court if needs be, and then after the trial as well. And in An Garda Síochána's commitment, they are the only organisation to actually specify disability within their commitment. And they say that if you have any form of disability, we will take your special needs or requirements into account. But it is notable again that this charter is not legislatively binding. So I've alluded to the fact that when we're discoursing disability, umbrella discussion of disability sometimes is insufficient for talking about deafness, because there are certain things culturally and linguistically around deaf identity that just never appear in discourse around disability. And so I'd like to use the opportunity in today's presentation to focus our attentions on some of those specific issues. So this will be very well versed to many of you in the audience, but perhaps less so for others of you. The Irish deaf community is a cultural and linguistic minority, and many members of the deaf community would actually refute the label of disabled. They would not accept they are disabled, and they would instead recognise a cultural and linguistic dimension to their identities, and this is really key. There are approximately 5,000 members of the Irish deaf community, and the first language of that group would be Irish Sign Language. And this is the specific category of people that I would have engaged with in conducting this research. Significantly, Irish Sign Language has neither official nor constitutional recognition in the Republic of Ireland. In the north of Ireland, Irish Sign Language shares official recognition with British Sign Language, but that is not the case here in the Republic. So that's a very significant issue, I think, as it pertains to deaf victims and their rights. Now, Benjamin Behan, he's a deaf studies scholar, and he has spoken around deaf identity and deaf people. And he makes a really interesting point around using sign language as first language. And he explains that deaf people use a visual language to communicate and have developed a visual system of adaptation to orient them in the world that defines their way of being. So quite discrete from hearing ways of being in terms of speaking and behaving in the fashion of one who listens. Deaf persons engage with the world in a very visio-gestural way. Visual cues are key, and significantly so too are bodily gestures and the use of sign itself. So then, in terms of understanding how disabled victims of crime have been recognised in a very limited fashion, even less so have deaf victims of crime been recognised. But in a study done by Brennan and Brown, which is probably a landmark piece of work that has been done around deaf people's access to justice in the UK, in the 2004 book written about this, Brennan and Brown have argued that the presence of an interpreter or interpreters can change the dynamics of legal interactions in ways that affect the outcomes of police interviews and court proceedings. However, there is a lack of awareness amongst many of those involved in the justice system about both deaf people and their language and the nature of interpreted interaction. So the conclusion in that report would have been a lack of awareness around deaf accessibility and the use of sign language in criminal justice settings. Herman has also written on this topic, and in his 2003 paper he writes that many crime victims face linguistic, cultural and social obstacles to participation in the justice system. For example, deaf victims cannot communicate effectively with police investigators or court personnel if the services of skilled interpreters are lacking. And very interestingly, Herman sort of parallels deaf people's experience with the experiences of migrant people whose language is not necessarily English or the first language of the state that they're living in. But I would like to point to a disparity that I see in my work between the ways in which Ireland has proven quite successful at adapting to a range of foreign spoken languages, and yet we see a persistent lack of acknowledgement or awareness around sign language. So there's definitely, if you want, a philosophical disparity between visio-gestural languages and spoken languages, and that's really something that has driven my interest in this research. So to talk specifically about this research project, in terms of recruiting participants, I suppose it was always known to me that the numbers of deaf people that might like to engage in the research would be relatively small, given that if we think about the number of 5,000 people totaling the deaf community, the numbers of victims therein would be smaller again, and then again smaller people that would be willing to share their experiences or talk about them. But I was very lucky to have the support and facilitation of a network of deaf organisations around the country who helped me to distribute my call for participation, and without that, essentially, really, this research couldn't have happened. The method used for the research when meeting deaf victims of crime was to conduct in-depth, semi-structured interviews. It was always made very clear to the participants that they need not necessarily disclose what crime had been perpetrated against them, but invariably it did come up in the course of the interviews. The research was done with the employment of qualified and accredited interpreters, and in every instance it was the interpreter of the deaf victim's choice that was booked to do the interview, and this was very important. The meeting location was similarly of the participant's choice. In some instances, the victims that I met wouldn't necessarily have disclosed to their deaf circles that they had had a crime perpetrated against them, and so they rathered not to meet in a deaf venue. And so we would meet in other places, like for example the UCC campus, or perhaps somewhere like a hotel lobby. Transcription and analysis then in that part of the process, anonymity was a really key factor, because again, people are very easily identifiable. When you have a community that is so small, certain factors can make it very easy to identify who you may potentially be talking about. So when it comes to conducting the research, transcription and analysis, I would have conducted that myself. In terms of the research profile then, a total of 7 deaf victims have participated in the research, and it's their sort of perspectives that will be built on for today's presentation. There was a nice gender balance in the sense of 4 women took part and 3 men, and also there was a good array of crimes represented among that small cohort. So there were people that would have had theft in terms of mugging or burglary, assault, both physical and sexual, and also targeted antisocial behaviour. So in addition to the interviews with deaf victims, I would also have met with representatives from deaf organisations, representatives from the victim support sector, policy perspectives from criminal justice agencies, and finally the perspective of Irish Sign Language interpreters to get their take on what's it like to work in criminal justice settings and what are the challenges that arise. So I had 3 main research questions driving the research, and they're set out on the slide. The first of which, how are deaf victims constructed within the Irish criminal justice system? So taking a look at some laws that are in place in this jurisdiction and looking at any reference to deafness or sign language that might tell us a little bit about the ways in which deaf people are understood. One example might be the Juries Act of 1976, for example, in which deaf people are included among those people ineligible to serve on a jury. And I think that those kinds of indications can point to some presumptions around deaf people's capacity to be agentic and effective participants in the criminal justice process. So that was the first of the research questions. The second was, to what extent would the principle of orality, which is implicit in the adversarial trial process, compromise the agency of deaf victims? So as a geographer coming to the land of law, it has been a real learning curve, and I've come to an understanding of how adversarial processes work in terms of living in a common law jurisdiction, and the real priority and emphasis that is placed on the spoken word within criminal justice settings. And so for me, this was very key to understanding what might the implications be for deaf individuals who don't speak and instead use sign as their first language. The third of my research questions, I wanted to find out, were there any levels of deaf awareness evident in the regulatory frameworks which govern the work of the Irish criminal justice agencies, and in particular now my interest is swayed towards the Victims Directive. I wanted to know, how do those compare with those evident in other named jurisdictions? So other common law jurisdictions would include the UK, Australia, Canada, New Zealand and the United States. So, in terms of understanding this issue about the disparity between voice and gesture, Padden and Humphreys are 2 well-renowned deaf studies scholars in America, and they have stated that deaf people often struggle with the problem of voice, how to make themselves heard over a powerful other voice of hearing people who define them and their needs differently. And following up on that point, Young, Ackerman and Kyle also allude to this in their work in the second quotation, deducing that a relationship between communication, confidence and identity is one that many deaf people are familiar with on a daily basis in having to deal with a mostly hearing and speaking world. So if we think about everyday interactions, I mean, the public sphere is for the most part a hearing sphere, and so imagining and thinking about deaf people's access to that sphere, perhaps when they are the only deaf person involved in the interaction, it opens up some questions about, I mean, what do we presume to be normal? Is hearing normal? But certainly deaf is normal for deaf people. So how do we sort of resolve then the tensions that can result from deaf hearing encounters and interactions? So in thinking about oralism and the priority we tend to give to speech in society, I was interested in looking further at the concept of adversarialism and more specifically orality within that process. So the focus or emphasis on the spoken word, essentially, that was my key interest. And in a paper by Burton, Evans and Sanders, they have argued that the role of orality in criminal justice process is the belief that juries are best able to assess the honesty of defendants and witnesses if they give direct oral evidence in person in court. So the notion of orality, it mobilises questions for me around access for deaf witnesses. It raises questions around the roles of interpreters in criminal justice settings, and to what extent potentially can deaf people be sort of the loser in a power imbalance or a struggle involved in encounters and interactions with other hearing people around them. The Law Reform Commission in Ireland have recognised that this is an issue. In their 2011 statement on this, they said the problems with communication, which can be particularly relevant in a legal culture which relies heavily on oral communication, have been identified as difficulties which the criminal trial may pose for the complainant, and the complainant very often being the victim of crime. But interestingly, conversations that have taken place around the Law Reform Commission's interest in orality have been more focused on intellectual disability, and we have yet to see sort of deafness making a sort of a profound input into that conversation. But I think we can very clearly see there is potential for looking at how this relates to deafness. Now, a sort of a theory that I have employed in my research, which is up on the board, is the fifth term down, articulateness. It's something that I'm very interested in, who is deemed to be articulate. So it's very clear to me that the more articulate you are in criminal justice settings, the more likely you are to have a fair go. So if you are well able to sort of defend your position, give your evidence very clearly, well then you're able to sort of take control over the progress of your case to a certain extent. But then for deaf witnesses who perhaps are relying on the mediation of interpreted communication, this can have ramifications for the extent to which they are given equity of access, the process. So Shrimp has written about articulateness, and essentially she argues that it enables articulate voices, such as white, well-educated male voices, and other voices that use voice simpliciter. And what's meant by voice simpliciter is a clear and distinct voice with no individual quirks or characteristics. Now, she specifically mentions in that paper people who use sign language, so who do not speak and communicate in a visual gestural way, but also persons that are perhaps have acquired deafness and maybe speak with a deaf accent. And her argument is that this idea of articulateness is not only raced, gendered, classed and sexualised, but it is also able-bodied. So we regard certain people that are able to speak clearly as normal, and then if other people perhaps choose not to speak and sign, or if they speak in a way that is less clear or heavily accented, we somehow regard them as other or different, and that can have ramifications for their equity of access in the system. So I suppose putting together the findings of the research, I would feel confident in arguing that the adversarial process is two things. First of all, I would argue that it's a very audist system. Audism has achieved a lot of attention within deaf studies in particular. It has achieved very little attention beyond deaf studies. But Bauman describes it as appearing in the form of people who continually judge deaf people's intelligence and success on the basis of their ability in the language of the hearing culture. So if somebody is able to speak clearly, even though they may be deaf, they are regarded as perhaps more intelligent or more effective than somebody who chooses to sign and not speak at all. That's just one possible scenario. Similarly, I would argue that the adversarial process is phonocentric, with phonocentrism meaning the belief that the spoken word is the ultimate communication. So Derrida would have written a lot around phonocentrism and argued that it is the power of the spoken word over other forms of communication. So the spoken word has more impact than words that are perhaps written or gesturally signed. So I would argue that our adversarial process is both of those things, and I'd like you to consider both of those theories in light of me sharing my research findings. So in terms of thinking about the adversarial process and how it works, in McEwen's paper, there is the argument that fairness can be achieved when parties are allowed control of their own case in terms of the selection of evidence and of the issues. But my suggestion would be that if a culturally deaf individual whose first language is sign language, they can actually experience a power imbalance when they are reliant on hearing individuals around them to ensure their equity of access to the system. And this is simply not acceptable, particularly since you can have a victim who is ascribed as being vulnerable. So an individual who is a victim is probably already vulnerable within the system, having experienced a trauma, but may be further victimised or secondary victimised, as Walkley puts it, by the response of the criminal justice system. So we will see some anecdotes later emerging from the data that was collected from deaf victims of crime, in which we'll see this happening very clearly, when deaf people are put into situations of having to rely on hearing persons around them in situations where that is not acceptable and should not be allowed to happen. Another significant issue is if we look around us in the criminal justice system and who's working in it. Who are the judges? Who are the guards? Who are the people working in victim support? Are any of them deaf? And this is something that was alluded to in a 2011 study in Norway. There's a quotation on the screen in which they consider the impact of this, the fact that all of the police force are hearing, all of judges are hearing, and then for deaf persons relying on those individuals to help them seek redress, this can have implications. And they suggest that the question of legal protection for deaf persons in the context of interpreting is hence a question regarding situations where deaf persons face hearing professional actors. So straight away, deaf people are set up into a relationship where they are reliant on hearing professionals to help them secure access to justice, more so than other victims around them. So in terms of how can we effectively respond to victims and what might that look like? For me, in thinking about this, the Garda Crime Investigation Report published last October has been really illuminating in this regard. It achieved a lot of media coverage because of some of the, I suppose, endemic flaws that are in the system. But it's very interesting to look at the issues that have been brought to light through that report. And one of the most interesting things is the way in which An Garda Síochána recognise the set of responsibilities that will be on their shoulders once the new Victims Directive is brought into law in November. And I've included some of these on the screen behind. And I'd just like to draw attention to the fact that they're all focused on the theme of communication and information access. So I think this is actually very promising in terms of equity of access for deaf individuals, because sometimes when we talk about disability, the focus can be on physical access or infrastructure, and there is sometimes a tendency to forget about equity of access to information, which is at the heart of the issue for many deaf victims of crime. So the first of the responsibilities that An Garda Síochána highlight would be to ensure that information is consistently provided to all victims throughout the criminal process. Second of all, to provide information to victims on how to access support, including medical, psychological and perhaps alternative accommodation if needed. Thirdly, to provide contact details so that a victim can communicate with the Garda about their case. And finally, to provide information on access to legal advice and the procedures available if a victim wants to make a complaint in relation to their case. So again, that's just something I suppose to bank in your memories and to consider it in view of the findings that I will share later, and to see how perhaps we have a bit of evidence to suggest that these responsibilities currently aren't being met to an adequate standard. Similarly, within that report, An Garda Síochána make it clear that the first interaction between a Garda and a victim is most important and can ultimately determine whether the victim will assist with an investigation. And again, this is a nice way of framing the victim as someone who is an agent in the process and who has a great deal of an important role in the process. But what's interesting about the report is that what's recognised is a disparity between people's satisfaction levels. So people who have had their home broken into or perhaps were mugged on the street, they generally tend to be happier with the response they receive from the Gardaí. But persons who perhaps suffer sexual assault were less happy with the response with which they were met by An Garda Síochána. But at no point in the report is disability discussed. And I think again this is probably, without any regard to deafness, the umbrella category of disability is not alluded to in that report, and that is significant. So returning to the theme of communication, the Victims' Rights Alliance report of last year, they make clear that under the Victims' Rights Directive, victims have a right to receive certain information about their case. The information should be given in a simple manner such that the victim can understand it. Furthermore, if a victim does not speak the language, then the information should be translated into a language which they understand. Now again, implicitly we have this idea about somebody speaking a language, and there is again no acknowledgement of other forms of communication such as visuogestural use of sign language. But what is enshrined in this right is the right to access to information and the right to information in your first language. We can see it just here, I've just highlighted from this report again, the Gardaí at the pre-trial stage, which is the reporting stage most often. And it just says that information should be provided both verbally, so in spoken form, and also in writing. Information needs to be in writing because families of victims are often not capable of absorbing information easily after the crime. It also goes on to say that information should be provided in plain English to facilitate victims of crime with literacy difficulties and certain disabilities. Again, here we don't have a strategic recognition of deafness or sign language, but what we do have at least is a broadening of the recognition of diversity among the victim constituency. So it's a positive step, but there's certainly potential for deeper engagement. Now, the research that we've mentioned, this isn't the first research that has been taking place internationally about victims' rights. And there has been quite a lot written about deaf people's intersections with the criminal justice process. But when I was putting together the proposal for this research, what I noticed was that most of that literature focuses on deaf offenders of crime. So it's focused on what it's like to be deaf and to be in prison. And there was a real lack of information about what's it like to be a deaf victim of crime. But some of the results that we see emerging from that international literature are listed behind me. The first being that you can have the wrongful conviction of an innocent party. Very often you will hear anecdotally of an individual trying to report a crime but being mistaken for the offender of that crime, again down to a lack of awareness around communication and sign. This would be complainants being mistaken for offenders. So somebody trying to report a crime but perhaps in a state of heightened trauma or emotion, their actual signing frame becomes increased, very agitated, and people can assume that they're behaving in an aggressive way, whereas this is actually a misnomer. So we've seen that written about in the literature. You can also have the aggravation of accused parties by the use of handcuffs, which impedes the ability to use sign language. So this would be the equivalent, I suppose, of gagging somebody that communicates by speech. And again, a lack of understanding about how that can heighten an individual's aggression, and situations escalate then as a result. You also have a lot written about the inadequate provision of sign language interpretation, but not only that, but at an appropriate level of skill. So you will often hear testimony within the literature around people who were dissatisfied with the level of interpretation support that they received, perhaps in court. And finally, you could have instances of inappropriate sentencing due to communication breakdown in the courtroom. And so I suppose on balance it's important to recognise that these access issues aren't just pertinent for the deaf community or just for deaf victims of crime, but similarly so that if somebody has committed a crime, that they are appropriately sentenced in that regard. So it works on both sides of the coin. But in my own research, the focus was on victims. Now, I'd like to share with you some very preliminary research findings which are emerging. Analysis is ongoing, but already there are some very strong themes emerging from this research. The first of those being a lack of continuity of access provision while a case is being handled. So we will look at some accounts given where we will see that there is not basic information passed on from one Garda to another or to different units of personnel when it really should be. The second core theme is communication, which I really think is an umbrella for all of these findings. The third is disenfranchisement, which is one of our key terms written up behind us, and essentially it just means a loss of control. And finally, a lack or under provision of appropriately qualified sign language interpreters. So it's interesting to see that this research is resonating with the international research in that regard. So, in the first instance, I'd like to present an excerpt from an interview I conducted with a crime victim that had basically experienced an assault quite late at night. She was a female crime victim, and it was a very traumatic experience for her. And so in learning from her experience through not being able to engage effectively with the Gardaí, her coping strategy was to carry cards which stated quite clearly that her first language is Irish Sign Language and she would like the cooperation of an interpreter. So she said in the interview, I have cards which say that I'm entitled to an interpreter, and that explains clearly to the guards. So she recognised herself that there was this disconnect in communication that happened, and she did something to sort of remedy it. But that was a very individual response, which isn't it isn't acceptable at all. There should be an institutional support for that individual. Something else interesting that happened, this victim, was that the Garda to whom she reported the crime, she was clearly very upset after what had happened, and the guard gave their personal contact details and suggested that she could text should she need to if she became nervous. And she did do that after the crime, but she said, sometimes I would text, maybe 3 or 4 times altogether, but I feel like if I text now, there will be no reply, because the guards have moved on. I suppose it's a private number, so that changes. I would love if there was a way of getting around the fact that you have to ring emergency services. So a key issue being alluded to here is the fact that for hearing members of the public, 999 is very readily able to be to be called if you experience any form of crime, or if you need to do anything at all, like book get the help of an ambulance or any emergency service. But that facility is not accessible to members of the deaf community. Now, there is a text service which we will look at a little bit more detail in a little while, but just for now to acknowledge that there is that disparity of access provision between deaf and hearing victims. In the same interview, I asked the lady how had she found specifically communicating with the guards, and this was her response. She said, when the attack happened that night, I was in such a panic and I didn't know where I was going. I couldn't text, I didn't have a number, I didn't know who to contact. I was going to go into town to the Garda station, but luckily enough I stopped and the man followed me and he was able to phone. I explained to the guards when they arrived on the scene that I'm deaf, so they wrote down the information, but I actually could not use the pen because I was so petrified. It was very hard to communicate with the guard, but there was a Bangarda, a woman guard, who was very easy to lip read, so I found it easier to communicate with her. And I think this quotation illuminates a number of issues. One being, I suppose, the ad hoc nature of it very much depends on what guard happens to be on duty when the crime occurs. And there are natural differences between individuals' dispositions and personalities and levels of awareness, and this is something that isn't systematically provided for. We will look a little later at the issue of training that is taking place for Gardaí presently, but I think this excerpt demonstrates that it's very much dependent on what guard you deal with that will dictate the response you receive. Similarly, again, we have a replication of this concern around not being able to text, and there is no number that this lady was made aware of, but also the fact that when the guards arrived, she found it comforting that they had arrived, I suppose, but frustrated ultimately at the lower levels of communication that she could enjoy with them. So that point relates back to the case of deaf people relying on a number of hearing people around them to help them to enjoy redress. One person explained their frustration at the actual architecture of the police station. They went there to try and report a crime. And this person said, I went to the Garda station and I was the only one in reception. I rang the bell, but nobody came. And here's me thinking the bell isn't working. Nothing to tell me if it's working or not. I rang it 3 times and the guard came out, opened the thing and said, yeah, they'll be out in 2 minutes. And there's no need to keep ringing the bell. I said, I'm deaf. I don't know if the bell's working or not. So this is a slightly different point around the architecture of spaces and the way in which, again, in police stations and courtrooms alike, there is a supposition that the public is a hearing public. But what about people that don't hear and rely on visual cues for information? Perhaps is there something we could do around this? Another crime victim that engaged with this research talked about their frustration at repeatedly trying to explain to the Gardaí that she's deaf and doesn't use the telephone. But after repeated attempts to convey this, she still received a letter. And what she told me was, their letter to me said, ring the guard's number. That's no good for deaf people. They knew I was deaf. I said to my husband, I'm not happy with that. I'm going to the police station and you're not coming with me. I go by myself. They think all deaf people are the same, that I will want to go to an organisation for support, but I don't want that. I want my independence. So I think 2 very important points emerging from this particular excerpt. The first being that her husband, who's a hearing individual, I did see a kind of very strong theme running through the interviews, whereby if a deaf individual had a hearing person accompany them when they were reporting a crime, that the tendency was for the guard or attending personnel to deal with the hearing individual, even if they had not been directly impacted by the crime. So this is an issue. And second of all, it shows this idea of understanding the deaf community as this homogenous group, rather than recognising actually a deaf person first and foremost as an individual, not supposing or presupposing that they will want to engage with a deaf network support, and this is a really important point. Interestingly, while the preceding quote showed somebody who didn't want hearing accompaniment, another victim had a different take on it. This was a male victim of crime who had been attacked at a taxi rank, and he said that he contacted the guards through the local Garda station. He said at the time it was very difficult. I went alone, but that was a big mistake. I needed help because the problem was making a statement. They want points in words, and I'm more visually orientated than when it's written down. I have to show them. So making the statement, points were missed out, and I ended up getting quite frustrated. But the Garda sergeant was fantastic. He said, okay, show me where it happened. After that, I felt like at least he was listening to me. So I think what's very interesting here is that this person felt very let down and disappointed in the response they received upon reporting their crime. But also I think it points to something quite innovative and interesting, maybe something worth exploring the potential of this, but to appreciate the visual nature of the deaf way and deaf culture, and to see is there an opportunity to sort of integrate that into our responses to victims. Is there a way maybe of adding to the written statement process which accommodates the visual orientation of a member of the deaf community? Possibly. The next theme that I had wanted to move on to was disenfranchisement. So if we recall the quote that I listed earlier in the presentation about people taking control over their own cases, this is very often difficult when you're a deaf individual reliant on the actions of hearing persons around you. So this particular crime victim, she was mugged on the street and 2 bystanders witnessed it happening. So when the Gardaí arrived on the scene, having been rung by the hearing witnesses, the Gardaí were talking to the other 2 women who witnessed the mugging as to how they heard me. So I don't know what the guard said to them. They were talking around me, so I was kind of a little bit sitting back. Now they were supportive, but at the same time I would have liked to have known more. There was no eye-to-eye contact. They were just talking amongst themselves. I was in a state of shock, and I forgot to say that they should have talked to me, but I was aware of that. And I think what's really interesting about this lady's predicament was that it isn't necessarily she would expect the Gardaí to communicate with her in sign language, but to have a level of deaf awareness around the importance of eye-to-eye visual contact when engaging with members of the deaf community. And so I think again there we might have a point that we could maybe reflect further on and see how that might be integrated into victim response. Similarly, another victim that participated in the research was the victim of a burglary while her husband wasn't at home. And yet when the guards came, it was the husband that they dealt with directly because the husband was a hearing man. And this lady's frustration was that they, meaning the Gardaí, were talking all the time to my husband. And I said to him, this is really bad communication. They never looked at me in the eye, they looked at you. But the victim is me. The stolen properties are mine and mine alone. I was in the house, it was me. So there's this awful sense of having had a crime perpetrated against this individual and the trauma that goes along with that, and then feeling that she's being written out of the reporting. You know, she's not being facilitated to be an active participant in reporting the crime and providing the statement. So that was quite frustrating. The final kind of key theme emerging from my interviews with deaf victims of crime would be the lack or under-provision of appropriately qualified sign language interpreters. So just to reiterate 2 things going on here, not alone the provision of an interpreter, but the provision of somebody that's appropriately qualified to work in criminal justice settings. So this excerpt comes again from the interview conducted with the lady that was assaulted late at night. And so she says that the first time it was so unexpected. The detective actually came to our house the following day to take the statement, but came unannounced. Didn't book an interpreter, just came unannounced and went through everything. Now my cousins signed to the best of their ability, but I prefer a professional interpreter. But the guards just didn't realise that they must provide a professional interpreter. So I gave the relevant numbers for SLIS, which is the Sign Language Interpreting Service, and then they rang for a second time and a statement was given under the communication of an interpreter. So there's a few levels to think about within this quotation. I suppose the first being the inconsistency in the handling of a case, so that the Gardaí that had originally attended the scene of the crime, somehow the information had not been relayed to the detective that came to take the statement that this victim was deaf. Second of all, the use of a family member who is competent in sign, but to the attending Garda's knowledge, how competent are they in sign and how well are they conveying the information, which is so important in the provision of a statement should the case be brought forward. And finally as well, I think what's very important is that the guards were not experienced or aware of the routes by which you actually book a sign language interpreter, and so the onus was on the deaf individual to provide that information. So again, to what extent is that helpful for the deaf person? Also given that it really essentially took 3 attempts before a statement was given in the company of an appropriately qualified interpreter at quite a time distance from the crime taking place. So definitely here I think what we do have is an instance of repeat victimisation. So the original crime was bad enough, but the response of the criminal justice system was so ineffective, it compounded the trauma. So I think it's useful to look at the provisions that exist for deaf victims, both here in Ireland and internationally. And many of these were identified in research conducted, again with Claire Edwards and Shane Kilcummins, funded by the Irish Council for Civil Liberties. They put together a compilation of provisions for disabled victims internationally. Now here in Ireland, I alluded to the fact that for hearing persons you dial 999 in the case of an emergency. Now there is a text facility available for anybody to use. It's not just for deaf people, and I think possibly the original impetus was to engage with younger people, and it's the 112 text facility. But what's very interesting about this, and I have it highlighted on the slide, is that it's necessary to register your mobile number with this service in advance. So I think that this is a really ineffective response to deaf victims, because nobody preempts becoming a victim of crime. Nobody preempts needing to access the emergency services. So we have a loss of that spontaneity that is needed in an emergency situation. So perhaps, and I know that there are genuine and valid reasonings behind why this is a pre-registration requisite, but still I think that it needs to be addressed because it's simply unacceptable. A positive measure is to see that the Crime Victims Helpline have made themselves accessible by email. And this previously wasn't the case, so it is very good to see the introduction of an email address by which they can be contacted, and this may be used by some deaf victims of crime. I wanted to point out that the issue around pre-registration for texting isn't specific to Ireland alone. And on the screen behind me here, I have just taken a screen grab from New Zealand first of all, and secondly from Western Australia. And in both cases, the pre-registration is required, but also it isn't in every situation for an emergency service. So if we look here in Western Australia, it specifically says it should not be relied upon in emergency, and the service only applies to Western Australia. So this service, again, it's a mechanism for communicating with the police force, but not in an emergency service. So I just wanted to make the point that these dilemmas aren't specific to Ireland. Sometimes I think we tend to think that we're maybe behind everybody else, but actually we see these issues replicated internationally. Police training is definitely a key issue. No research to date, much has been published in Ireland on this, but in the UK in 2011, the organisation Sign Health did publish a very short report called Deaf People in the Criminal Justice System. And within that report, they highlighted the need for improved training. So they said that within national police training, there appears to be no prescribed training in deaf awareness. They also said that there are no specific learning objectives for deaf awareness, but it may well be mentioned in practice in lessons such as effective communication, diversity training, statement taking and suspect interviewing. However, this is quite ad hoc, it's not systematic or strategic, and it may mean that certain cohorts of Garda graduates are leaving training college without having any mention of deaf awareness brought to them, whereas other cohorts may have it introduced to them. So we see an inconsistency there. If we look back again towards the Victims Directive, this very key issue of training is brought to the fore therein. They talk specifically in Article 25 about training practitioners. So they say that member states, of which Ireland is one, they should ensure that officials likely to come into contact with victims, such as police officers and court staff, would receive both general and specialist training to a level appropriate to their contact with victims, to increase their awareness of the needs of victims, and to enable them to deal with victims in an impartial, respectful and professional manner. So herein again we have another of these responsibilities or obligations that will have to be met under the terms of the new directive. In the United Kingdom, there's a PLOD initiative, with PLOD being an acronym for Police Link Officers for Deaf People. And I think it's a useful model to look towards for perhaps community-based engagement with deaf communities. So essentially, PLOD officers are police officers or police staff, so it may be civilian staff working in Garda settings, who have volunteered to work with deaf people or people with hearing loss. They promote understanding of deaf issues within the police. All PLODs are trained in British Sign Language and continue to get training in deaf issues. So it's a kind of a continuing process, it's not just a one-off training. All PLODs have contact with local deaf organisations, and when their shifts allow, they will go to meetings. The PLODs cannot act as interpreters, but will help with victims of crime or where British Sign Language is needed. They will also help, where possible, if communication is a problem. And I think the PLOD initiative is useful in that it highlights this need for appropriately qualified sign language interpreters. So a basic level of sign is not going to be sufficient in terms of an important interaction in a police station, like the reporting of a crime or perhaps the delivery of testimony in the courtroom. But what the PLODs can do is to be deaf aware and to have perhaps basic level of sign until an interpreter is brought onto the scene. So I think it's perhaps a useful model that we might look towards. I spent some time in the London Borough of Bromley as part of my PhD research, and at the time a Metropolitan Police initiative was brought to my attention by people that thought I would be interested, called Deaf Link. And what that entailed was basically, again, training of police officers, and it was a partnership strategy between the local deaf centre and the local police station. And essentially it meant that people were better equipped to respond effectively to deaf victims of crime when they came seeking help. But interestingly, 6 years later, having revisited Bromley to sort of find out more about the scheme, it has since collapsed. And I think it is a kind of a warning sign that a lot of these schemes very often rely on the voluntarism of interested officers. So if somebody has a natural interest in deafness, perhaps they have a deaf family member, or they are just maybe sign language learners, that as long as they're in that station, the scheme will work effectively. But should they move on, we see that that kind of level of support disappears very often abruptly. In terms of opportunities for engagement in Ireland, I think there are many. A very positive development, I think, has been the establishment of the Crime Victim Service Offices, of which there are 28 nationally, just established in March of this year. And so I think that there's a really focused commitment to engagement with victims that we're seeing coming through An Garda Síochána. And so perhaps the diversity initiative that is being sought might be something that we could strive for in that setting. But something else that I think is also very valuable in terms of deaf victims is the very focus on communication and information that we see in the Victims Directive, because it moves us beyond the very limiting scope of talking about disability, which sometimes focuses too much on physical access issues and with no regard to deaf awareness. Now, I wanted to allude to a good practice case study here in the Republic of Ireland, but not to dwell on it too much, because we will be hearing a lot more about it in the afternoon session. But it is the collaboration between Women's Aid and the Irish Deaf Women's Group, which resulted in much of the Women's Aid website content being interpreted into Irish Sign Language and made widely available online. And so I think, again, what we have here is an initiative where we saw a long-standing relationship, grassroots led, between a deaf organisation and a victim support organisation. And when those kinds of relationships happen and are enabled, we can see very real, tangible, positive outcomes. But I won't say any more about that. I look forward to hearing more about it later. So in terms of drawing to some conclusions then, I suppose ultimately this research has been more about generating questions as opposed to finding solutions or answers. The first key question would be, how can we ensure that we are responsive to the diversity of the victim constituency? So my particular research interest has been with deaf victims of crime, but I do think there are issues herein that do translate very well onto other categories of victim also, particularly when you think about the broader issue of communication. Secondly, how might we develop critical awareness around orality in the adversarial system? If orality is something that is so long ingrained in our criminal justice system, can we perhaps address it and see, well, what do we mean by orality? Can we innovate within that term and factor in visio-gestural communications also? And finally, I'd like to consider maybe what measures can we take to meet the language rights of members of the deaf community whose first language is Irish Sign Language. And I think that's probably the fundamental question kind of arising from the research. I'd like to conclude by framing my research and my research findings in terms of understanding language access as fundamentally a human right. So in as much as we have an obligation as a member state of the European Union to demonstrate how effectively we're responding to victims, essentially it's about meeting people's human rights. And Haviland and Lannon, again, two deaf studies scholars, they have written in their work that it's necessary to recognise and promote the use of sign languages to secure the fundamental right to freedom of expression and opinion is granted to deaf people. So when we say yes to sign language, we say yes to deaf people. But if we say no, it's the same as saying no to deaf people and their opportunity to enjoy equal citizenship. So I think that's just the fundamental case here of it being a case about language access and human rights. And essentially we're obliged, I think, to address those kinds of issues. So on that note, I'd really just like to thank you for your attention, and I'd welcome any questions. I do think we have some minutes for questions and answers.